Okay, again, I'd like to welcome everybody to the Planning Commission meeting for the City of Salem for Tuesday, February 26th, and we will start with a roll call. Ellen?
Commissioner Lewis,
Here?
Commissioner Fox,
Here.
Commissioner Fry,
Here.
Commissioner Palmatier, Commissioner Williams,
Here.
Commissioner Blassie,
Here.
and Commissioner Guyer, acting excused, Commissioner Fry. We have a quorum.
All right, thank you. First order of business this evening is the oath of office, and we have with us tonight one new Planning Commission member. So, Sharon, would you come forward and take the oath of office?
Thank you.
Commissioner Blassie, if you'd just repeat after me. I, Sharon Blassie,
I, Sharon Blasey,
do solemnly swear or affirm that I will support the Constitution
do solemnly swear that I will support the Constitution
and laws of the United States of America
and laws of the United States of America
and of the State of Oregon and the City of Salem,
and of the State of Oregon and the City Charter and Ordinance of the City of Salem,
and that I will do my best to of my ability
and that I will do to the best of my ability
faithfully and lawfully perform the duties of Planning Commissioner for Salem during my continuance therein.
faithfully and lawfully perform the duties of Planning Commissioner for Salem during my continuance therein. Thank you.
All right, congratulations, Commissioner, and welcome to the fold. Next order of business is the election of officers, and there is a need to election of a president and a vice president. Do I have any nominations?
I nominate Jim Lewis for president.
I'll second that.
All right, any other nominations?
I'd like to nominate Rich Fry for vice president.
I'll second that.
All right, anything else? All right, all those in favor of the nomination say aye.
Aye.
Any opposed? All right, thank you very much. This brings us to any communications from council, boards, commission, or agencies. If there's anybody in those categories that has a request to speak to the Planning Commission, if they would come forward now. And seeing none, this brings us to our first opportunity for appearance of interested citizens. This time is available for interested citizens to comment on specific agenda items other than public hearings, deliberations, and merits of land use issues that are reviewable by the Planning Commission at public hearings. Is there anybody who wishes to speak to the Planning Commission? If you'd come forward and...
This is for the public hearing 6.1.
Yeah, and we'll be getting to the public hearing testimony shortly. Okay. All right, next we have our consent calendar, and on the consent calendar there are minutes from our revised minutes from our December 18th meeting and also our January 8th meeting. Would someone make a motion for the consent calendar?
I make a motion that we accept the consent calendar as presented.
And I second that.
All right, any questions, comments? All right, all in favor of the motion, say aye.
Aye.
Opposed? All right. This does bring us to our first and only public hearing for this evening. And before we start the public hearing, I'd like to read the following statement into the record. I would like to note that, for the record, that it is possible that individuals I have, or could have a business relationship with may be participating in tonight's decision-making process. I am currently unaware of any such individual's intent to participate, but will advise the Commission at my first opportunity if my situation should change. I make this disclosure to fulfill the requirements of Section 62 of the City of Salem Charter. Would all commissioners who would like to make the same declaration do so by raising your hands? And let the record show that all commissioners raised their hands. Before we start, I was curious, could I see a show of hands from the audience on how many people are here to testify tonight at the public hearing? The rest of you just thought there was popcorn, right? No. Okay. We'll go ahead and get started. Tonight's public hearing is on agenda item 6.1, and it is code amendment case number CA 10-04 regarding wireless communication facilities. And if we could start with Mr. Gross would like to make a comment before we get started.
Thank you, President Lewis. Yeah, folks, I want to thank you for coming down tonight. I think a lot of you are here because you received a little postcard in the mail from us. First of all, let me tell you that I'd like to apologize for the language of that postcard. It wasn't as clear as it could have been, and we would do it differently if we had it to do over again. The language, a lot of it comes from state law. We're required when we consider adopting an ordinance that would regulate land use citywide, we're required to send a notice out to property owners throughout the city. So every property owner in the city of Salem received that postcard. We're also required, since the proposal could conceivably limit what somebody could do with their property, we're required to make a reference to property value. And again, if I got that and I didn't know any better, I would think it was scary. But really what we're here to talk about tonight is the city of Salem needs to update the way we regulate wireless communication facilities or cell towers and antennas, dishes, that sort of thing. That's all this is about. It's not about a proposal to locate a cell facility in your neighborhood, near you, on your property, or anything like that. It's about how we regulate them going forward. So again, thank you for coming tonight. I hope you find the presentation informative. If during the meeting you would like to talk to a planner, there are several of us around. They have the little name tags on. Just grab one of those folks and they'll be happy to talk to you about any question that you may have. Otherwise, I hope you enjoy the public hearing. Thank you.
If I could remind the commissioners and anyone who testifies to speak directly into the microphone, since we are on TV tonight, we need to make sure that they pick up the audio version also. And we will start with a staff report. Pamela?
Good evening, Commissioners. I'm Pamela Cole, Associate Planner, presenting the staff report for Code Amendment 10-4, a proposed update of Salem's Wireless Communications Facilities Code. I'd like to request that the staff report and its attachments, as well as additional written testimony submitted for this hearing, be entered into the official record. I'd also like to correct the subject line on the staff report, which should read, Proposed amendments to the Salem Revised Code establishing a new wireless communications facilities ordinance, SRC Chapter 715, amending and supplementing existing provisions for wireless communications facilities in SRC Chapters 116, 118, and 119, and making associated corresponding amendments to the applicable chapters included under Title 10, Zoning Code, of the Salem Revised Code to establish consistency with proposed SRC Chapter 715. The existing code was adopted in 1996 and regulates antennas, equipment, and cell towers based on zone. Since 1996, technology has changed. People are depending on wireless communication for calls, texts, data, and entertainment. Customer demand has prompted providers to look for new ways to provide service, including antenna deployment on utility poles in right-of-way. Our current system of franchise agreements for facilities in right-of-way results in different requirements for different providers. To balance the need for service with the community's desire for compatible facilities, staff began the code amendment process in 2009, working with a consultant and reviewing codes from other jurisdictions. We circulated early drafts to wireless communication providers, utility companies, and neighborhood associations and received and reviewed their comments. Many of the provisions in the proposed code are based on the type of structure that supports the antennas. Antennas can be attached to buildings and other support structures, such as water towers. Utility structures, such as power poles and light poles. And support towers, commonly known as cell towers. The photo on the right is an example of a camouflage cell tower designed to resemble a tree. Staff developed the ordinance based on a preferential siting model to encourage providers to locate facilities where they have the least impact on surrounding areas. The key feature of the proposed code is the siting priority. First priority is to attach antennas to a structure outside right-of-way, such as a cell tower or water tower. If the applicant documents that first priority won't work to provide needed service, the next option is to attach antennas to a utility structure in public right-of-way, such as a power pole or light pole. If that won't work, the next option is to replace a utility structure outside right-of-way and attach antennas. I've had one example of that in Salem where a light standard at a stadium was replaced for the purpose of attaching antennas. If that won't work, the next option is to replace a utility structure in public right-of-way and attach antennas. If that won't work, the next option is to replace or substantially increase the size of an existing cell tower. And finally, the very last option is to build a new cell tower. For facilities in right-of-way, the siting priority is also based on street classification according to the Transportation Systems Plan. An applicant would have to prove that a facility located on a parkway or freeway, major arterial, minor arterial, or collector street wouldn't be able to provide the needed service before obtaining permission to place those facilities on a local street. In response to the citywide mailing on January 22nd and at 2 open houses, staff has had the opportunity to discuss the proposed amendment with many interested citizens, as well as wireless industry representatives. Written comments we received prior to February 19th are included in the staff report. We've received additional written comments in the past week and have made copies for the Planning Commission and attendees this evening. We've received comments from several wireless industry representatives. I've only included 3 of those on this slide. First, they're concerned that the proposal would increase processing time beyond the Federal Communications Commission's time limits of 90 days for co-locations or attachments on structures and 150 days on other applications. Staff does not recommend any changes to the proposal based only on this comment. Many co-locations on existing support towers and other structures would be exempt from siting permits. Staff generally processes other co-locations in less than 90 days, and decisions for other land use applications would be issued within the state-mandated 120-day decision date. Second, they're concerned that the standards are inflexible and a variance would be required for any deviation from a requirement, such as the camouflage design standards for new support towers in certain zones. Staff recommends adding adjustment provisions for minor deviations from certain standards, but we do not recommend changes to the camouflage design provisions at this time. Third, they've requested that the city retain third-party consultants to review applications only when genuine issues arise, and also that the city limit fees in those cases to reasonable amounts. Staff's recommending no changes to this provision at this time because we believe the city should retain flexibility in this matter. On this slide, I've highlighted several comments that we've received from citizens concerned about impacts of wireless communication facilities. First, several have asked that we expand the notification area from the standard 250-foot radius for land use cases to a 500 or 1,500-foot radius. We aren't recommending increasing the radius at this time. That was established in the procedures ordinance, and exceptions increase the likelihood of procedural errors. Second, several people have asked that we retain the current 35-foot height limits in the single-family residential, duplex residential, and the multiple family residential 1 zones. Staff proposed increasing the maximum cell tower height in these zones to either 50 feet or 70 feet. The maximum height code currently allows for non-residential structures in the zone. We believe the increase in height is reasonable in combination with proposed camouflage design standards and the provision that restricts heights of cell towers within 300 feet of these zones to the maximum height allowed in these zones. Third, several have requested that we retain the current requirement that towers greater than 35 feet in height be set back at least 300 feet from residential and commercial office zones. Others have asked that we apply this 300-foot setback to healthcare facilities and schools. Staff recommended this reduction to 30 feet, which is a significant change, in combination with landscaping requirements, camouflage design standards, and height limitations that we believe mitigate visual impacts. Over the past several years, what we found is that wireless providers have applied to place facilities near residential areas to serve customers in those areas. And because large areas of the city are zoned residential, it's difficult for wireless providers to find suitable commercial or industrial zone sites that are more than 300 feet from all residential and CO zones. And we've received several variance applications in recent years to reduce the setback in order to provide needed service. Finally, we have received multiple comments from citizens concerned about possible health impacts of radio frequency emissions from the towers and antennas. The Federal Telecommunications Act prohibits the city from regulating location or placement of wireless communications facilities on the basis of environmental effects of radio emissions, so long as the facilities comply with the FCC regulations for emissions. We will be requesting documentation from applicants to certify that their facilities would comply with the FCC regulations, and we do not propose at this time to monitor the emissions. And this concludes the formal presentation at this time.
All right, thank you. And what we'll do, what we've done historically is hold off on questions for staff until we've had testimony, because sometimes the answers come out in the testimony. If not, we'll have questions for staff afterwards. Is there anybody representing a neighborhood association that wishes to speak to this issue tonight? All right, then we'll start with the list. And again, as you come to the podium, and you can speak to either side, if you would move the head this way so you can get a good connection for your voice. And if you would give us your name and address. And we'll start with William Howard.
Good evening, Mr. Chairman, members of the Commission. My name is William Howard. I'm a project manager with Odelia Pacific Corporation. My office address is 8960 Northeast Alderwood Road, Portland, Oregon, 97220. Odelia Pacific Corporation is one of the principal development contractors for T-Mobile West LLC, and I'm here speaking on behalf of that company this evening. We have provided, and I think you have before you, a letter that was submitted this afternoon by Corporate Counsel Monica Swoboda. It's not my intention to go through in detail the points that we've raised there, but rather to touch on what we think are areas of significant concern that still remain with the draft that you have before you here this evening. T-Mobile West operates 33 antenna facilities inside the city limits of Salem, 7 of which are inside the right-of-way regulated by the city itself. We have a long history of working with the city, developing our facilities, getting the coverage where our customers are demanding it, and in all cases using to the greatest extent possible existing structures in terms of co-location, rooftop mounts, utility pole right-of-ways instead of new communication towers. Our desire is to continue that good relationship with you, and notwithstanding the amount of work that has gone into this, which we acknowledge is considerable, there have been developments on a federal level since this process started in 2009 that we don't feel have been adequately or fully adopted and recognized in the draft that you have before you tonight. In 2012, Congress adopted what's referred to as Section 6409, where it streamlines the procedures for these co-locations. This ties in hand with the 1996 Telecommunications Act, making it a federal national policy to extend wireless services, to extend coverage to the greatest extent possible, and to, while acknowledging the authority of local zoning jurisdictions, to put those in a posture where actions are not taken that either conflict with federal law or that detour the national policy of building what we are talking about here as a national wireless infrastructure. 6409, the adoption in 2012, was one which set forth the time limits that Pamela had referred to earlier. It also sets forth, as a matter of federal law, what are considered base stations for this streamlined proceeding. One of the issues that we have with the draft before you tonight is that, notwithstanding that federal definition, which has been reinforced by a white paper issued by the FCC in just January of this year, this ordinance, the draft you have before you tonight, splits off antenna arrays, and it separates auxiliary equipment, and it attempts to regulate those separately, contrary to the federal mandate in Section 6409. Another concern that we have, as expressed in Ms. Wilgo's letter, is the numerous siting priority classes that Pamela spoke about earlier. As drafted before you tonight, there are no less than 6 separate priorities that are to be implemented and attempted to be applied not only by staff but also by the carriers. We are here trying to get the coverage to our customers. Our customers are your constituents. In that respect, we are all working for the same base of people and trying to provide the same levels of service. We have proposed, instead of the 6 cumbersome properties, siting priorities, a level of 3, which more readily represents the level of impact to be expected from these antenna installations and their associated impact on the neighborhoods. There are a number of permitting requirements inside the draft which create significant barriers to entry for wireless carriers that are not only established here, but those that may be trying to come in. I want to backtrack just a minute and talk about some national trends. There was a brief mention of 3G, 4G, and LTE services. As a matter of national statistics, within the next 2 years, there will be more broadband, more internet demands from mobile devices than there will be from laptop and desktop CPUs. These are the pressures that we're facing as wireless communication providers. These are why we have to continue developing these facilities. And increasingly, because price parity was reached between mobile phones and landline phones about 3 years ago, that demand is increasingly coming from the residential areas. And the draft that you have before you discourages and in some cases flatly prohibits us from getting into those residential areas, which is where we're facing the most strenuous demands. There is a balance. We certainly understand that. As we pointed out in the letter, there is a proper role for a balanced, thorough regulatory scheme which takes all of the interests, not only the communities and the neighborhoods, but also the customers and the carriers, where we can get these facilities in a measure that minimizes their impact, that continues to deliver the goods that are demanded by our customers and your constituents. And we're asking for a reconsideration of the areas of the draft that we've put forth in the letter. I know I'm running short of time. I'll close my remarks with that, and of course I'll be happy to answer any questions.
Are there any questions for Mr. Howard? Commissioner Blasey.
Thank you, Mr. Howard, for the presentation. I do have a couple of questions just to clarify. You were speaking about the proposal of the 3 siting priorities versus the 6.
Yes, ma'am.
And flipping through the document that we received just a few minutes ago, it looks like on page 5 there's a discussion about reducing those, but I don't see where it refers to 3 siting priorities.
You may be referring to another. There's a couple of letters that were attached to there. The very first attachment behind that yellow sheet is the letter from Corporate Counsel Monica Sloboda.
Okay.
The three that we're talking about are on page 2. I have an additional copy here if you haven't
Okay,
received it.
no, I do see it now. Thank you.
Yeah.
Okay. Thank you.
Any other questions? I've got one if I could. How often do you get complaints from customers about lack of service? And how often do you, when appropriate, respond to them that the city rules and regulations make it difficult or prohibit us from serving you because of where you live?
We get complaints, I don't want to say frequently, but we get complaints continually. And this touches on one of the issues that we've raised in our letter. The ordinance, by and large, is directed towards coverage issues, where we're trying to expand our wireless footprint into new areas that are not currently being served. And you'll see those standards repeated for 4 or 5 of those citing priorities. A larger issue that we're facing as an industry isn't coverage, especially in developed areas like the city of Salem. What we're facing is capacity, where the existing antennas that we have out there, because of growing demands from our customers, more voice calls, more and longer duration of voice, data, and broadband calls, we have exceeded the sheer capacity of that network to handle that volume. And if you think of coverage from these antenna sites like an umbrella, the more use, the more demands they get, that coverage shrinks down. And so what we're facing with and what we're frequently responding to more than coverage issues is a capacity question. And while there may be many people here that think their coverage is good, their wireless service is good, we don't need anymore, the fact of the matter is that can change within a matter of months. More customers enroll, more people start relying on their phones, particularly in the residential areas where they dismiss their landline completely and they rely more heavily on their cell phones. They start using the voice, the data, and the broadband services, tying into what I said before about the national trend. Within 2 years, there's going to be more internet traffic from those mobile devices. That's what we call a capacity site. And we are dealing with more than half of our network improvements as capacity issues. And the issue that we have with this draft is if you go through it, network capacity is only recognized in that 21-page ordinance 2 times, both of which require a public hearing.
Commissioner Palmetier.
So following up on that statement regarding capacity, when you improve capacity within a community that already has cell towers, do you add more cell towers or do you add more equipment on the existing ones?
If it's possible, if we have an antenna, if we have an array with only 6 antennas and we can add more to that site, then we'll certainly do that as a first resort. But if we've already got 9 antenna arrays and there's nothing more that we can add, then we're looking at putting something essentially in the middle. It usually is not quite as tall. We're not trying to spread the coverage out, as I said, but we have to come in and basically fill what has become that service dissipation right there in the middle. So it can result in a new communications tower site. Obviously, it's a last resort to us. We'll do what we can to upgrade the existing antenna facilities that we have, but as Pamela recognized, we ourselves are confronted with our own federal limitations. There's only so much power we can put out from these sites. It's not a matter of turning up the volume or turning up the power to get that coverage back out there.
How far apart are cell towers generally now, physically?
There are so many variations, it's impossible for me to give you a straight answer.
Based on terrain and
Yeah,
on a
but
flat
see, that's the
ground,
problem. That's the problem. If, back in the analog days, and I know nobody has an analog phone anymore, but back in the analog days, if we had level terrain, that was when we were building much taller towers, 400, 500 feet. We could easily get probably 3.5, 4 miles out of one antenna array on a tower. But with the change to digital PCS, with the shorter wavelengths, the increasing demands on the 3G services, voice data, and broadband, those heights have come down because we simply can't shoot from those tall heights. As a general rule, and again, this is subject to topography, it's subject to terrain, it's subject to use, a typical digital PCS antenna at, let's say, 150 feet, which is one of the taller, utility, the transmission towers, the cell towers. Putting aside capacity questions, as a general matter of coverage, we can typically get maybe 1.5 miles on each side, so probably about 2.5 to 3 miles in total from that one
if
site.
you're increasing capacity, then you'd have to place them between?
Yes.
Yes, okay. I
Yes,
get it.
ma'am.
Thank you very much.
Any other questions? I have one more, if I could.
Sure.
What level of participation has your company had with the city of Salem in the discussion of the creation of this ordinance?
We have written to the staff on, this will be the fourth occasion here this evening. We did have some personal meetings with T-Mobile representatives, and I believe it was the city attorney. This is something that has had our interest and our attention since the process started.
I have one.
All right, Commissioner Williams.
Thanks for your testimony, Mr. Howard. You were talking about Federal Regulation 6409 and two types of equipment, the antenna arrays, and what was the other?
Well, the 6409 regulations, and they're addressed in our letter as well as the white paper that's attached to it.
Right, but you were talking about
Right. Federal
the
law-
inability to break the two apart?
Yes, under Section 6409, that regulation, in terms of processing co-location applications, it talks about a base station. Under federal law, as shown in that white paper, the base station includes the antenna, it includes the lines, it includes the ground equipment, it includes the electronics that go into making that a functioning cell site. And that, again, is the federal definition, but if you look at some of the proposed definitions in the draft ordinance, that equipment is split out. And I think that's a grave concern under federal law.
Okay, thank you.
Any other questions for Mr. Howard? Commissioner Velazquez.
Thank you. Mr. Howard, I do want to go back to the proposed revised permit classifications that are outlined by the white paper that was provided. So my understanding is that that you all are proposing 3 classifications versus the 6.
Yes.
And so in looking at the differences between these, it appears as though the difference is the 6 that the city is proposing is within the right-of-way, outside the right-of-way for each of the 3 classifications, whereas the proposal that has been submitted does not distinguish between those 2. Can you speak to that?
I think that's correct.
Okay.
And while we understand, and in fact we agree with the goal of making the right-of-way development standards consistent among the carriers. I wasn't aware that there's variations in the franchise agreements. T-Mobile has a franchise agreement with the city. To the extent that there are those variations, it certainly makes sense that there be one uniform set of development standards for the right-of-way. However, that can be accomplished, I think, separate and apart from having to make a numerous and cumbersome siting process where those development standards, they have become, if you'll permit me, very convoluted. And we point out one of the impacts in our letter right there. Although the stated goal of the draft is to encourage co-location and use existing facilities, there's one classification in there where we're down at the 5th level. And that is a public hearing, the 5th priority level for us to go in and swap out an existing tower with an existing height. Now, why should we have to go back and reopen a fully permitted, already constructed, fully operational antenna site when we're making no more impact on that neighborhood? We're not doing anything to change the appearance. And yet, under the ordinance that you have here before you tonight, all that's going to require a public hearing. Those are the kinds of distinctions that I think need a closer look, if you will, and we'd be happy to continue our work with the city staff in an effort to resolve those conflicts.
Thank you.
Any other questions for Mr. Howard?
Thank you all for your time.
Thank you. Next, Ken Lyons. And I failed to mention it first, but each speaker has 5 minutes to talk. After 4 minutes, the yellow blinking light will come on, and at the end of the 5 minutes, the red light will come on, and that's the time to stop.
So that means I'll start talking faster when I see the yellow light, and even faster when the red one comes on. Yeah. Hi, my name is Ken Lyons, Bush Law Firm, on behalf of AT&T. Appreciate this opportunity to come and comment on what has really been a lot of hard work on behalf of the Planning Commission, the City Council, and definitely the staff that has gone through many, many iterations of this. And we definitely want to acknowledge their hard work and your hard work on this topic, and appreciate the efforts and the care that you're putting in to take a look at this. Just a couple of things, and I can't cover everything, and I won't try to cover everything. I did submit a letter. It's in the record. It was passed out tonight, I believe, to you. I want to highlight just a couple of things, but I'll also start, though, by recognizing also the importance of wireless facilities to the Salem community. About 35% of Salem residents do not have a home telephone. They rely on wireless communications as their sole and primary form of communication. And the CDC actually published a report that actually shows that number is expected to double in 5 years. That means that a majority, a very clear majority of Salem residents will likely ditch home telephone service in favor of having a wireless communication, just because why would you pay twice? And part of it's economics, part of it is how robust the services have become. I'll also echo one more thing that the representative from T-Mobile mentioned, and that is demand for wireless services is exploding. In the last 4 years alone, AT&T has seen the growth on its data network expand exponentially by 8,000%, and that's actually accelerating. It's getting even faster. So clearly, these facilities are very, very important. Finally, I would mention that over 70% of calls that come into E911 to 911 services come from mobile phones, and that recognizes the need, and not just as wireless at one point, maybe 10, 15 years ago, was thought of as a kind of a nice-to-have sort of technology, and it's really become critical infrastructure. It's part of the backbone of not just a carrier, but really the city does depend for business, for economic development, for communication, for residents, for virtually every single purpose. As I said, I can't cover everything. I just wanted to focus on a couple of major things. And I know that there are some other major things that other people might have that they might bring up, but I'm going to focus on a couple things. 90%, we think that more than 90% of the applications that the city is likely to see from here on out are for upgrades to existing sites. In other words, the number of new towers or new facilities on utility poles, things like that of that nature, is likely to be quite small. Every couple of years, even faster than that, carriers are coming in and upgrading their existing facilities. They're swapping out antennas, adding equipment, adding battery backups and generators in case of power outages, and things like that in order to keep up with demand. But in terms of the scale and the number of applications you're actually going to see and how the code will actually be applied, most of it will apply to upgrades to existing sites. And to that end, I will just mention basically 3 or 4 big things. Number one, as the representative from T-Mobile mentioned, replacing an existing tower is 5th on the priority list. Now, I can tell you the best way to prevent brand new towers to be built anywhere in a neighborhood is to actually replace the ones that are there as they become structurally overcrowded or overloaded. And it's not just that's needed in order to incorporate new technologies. It's also a public safety issue. Does the city really want to have towers that are structurally overloaded or at capacity and not allow those to be upgraded or be replaced, even like for like? We also think that that's probably also inconsistent with the new federal co-location law, Section 6409 that was mentioned. I mean, clearly, the tower is being replaced. You're not substantially increasing the size of it by replacing it like for like. It certainly would be about the same size. Wow, I have to talk faster. All right. So that would be one thing, is that we definitely think that that should be removed from the 5th priority, at least replacing structures. Now, substantially increasing the size of structures, that's a different story. But if you're talking about replacing existing structures, we believe that that should be removed from the priority list and placed elsewhere, perhaps up in the exemption section or something like that. Number 2, I just wanted to kind of mention some of your antenna standards. I think that the FCC bulletin that came out at the end of January does talk about base stations in a way that it actually does apply to rooftop antennas. It's not just attachments to existing towers. It's also existing facilities that are on rooftops and other types of site types. It's a very, very important thing that the code did not address, and so that will need to be looked at to make sure that those sites can be easily upgraded without having to do certain things. Plus, there also needs to be some outlets. Those rooftop facilities, some of the screening techniques that are proposed are definitely very good ideas, but the problem with them is that they could potentially require especially if if the antennas are structurally overloading that rooftop, there needs to be some flexibility built into the code for that. And I'll wrap up very quickly because it's even faster. Finally, I'll just mention that I do think that your variance process, you need another safety valve. I think the variance process was intended to be used very sparingly, but because of how you have so many things that say that a facility shall do this and shall do that, it's likely that that variance section is going to be used quite frequently, certainly quite a bit more than what was intended. And so we think that it makes sense to provide staff with at least some administrative level of discretion, or maybe discretion provided in a process that would make it a little faster and simpler to be able to administratively modify within certain limitations in order to get these sites done. And I think that's all I have time for.
All right, are there any questions for Mr. Lyons? All right, thank you for coming down tonight. Next on the list is Jim Carver. And if you could give your name and address, please.
Jim Carver, Portland General Electric. I'm based in Beaverton, Oregon, but I cover PG's service area. I'm responsible for all co-location on PG utility structures. Go through my desk. We have just a few comments. We're asking for some clarifications, starting with the reference in the definitions on a guy pole. Our question is, if a guy pole has service drops on it, is it no longer a guy pole? A little further on, it talks about suitable utility structures for co-location and mentions guy poles. And then further in the code on section 715.040, David 2, it prohibits guy poles. So we're kind of confused on that. Maybe that could be cleared up a little bit. The next issue we had was a clearer definition under section 2 of an engineer's certification. What are you talking about for an engineer? Are you talking about a typical power company engineer? Are you looking for a structural engineer, wet stamp drawing? If there could be a little more clarification on that, we would appreciate that. The next issue was on the minimum pole diameter. Portland General Electric's construction standards exceed the bare minimums as allowed by both national and state law. We think this is just prudent for public safety and for the integrity of our system. We never do will construct to just the bare minimums. We like to have an extra margin in there. Part of that not only protects the system itself, but in many cases, people like to add things to the poles after we've already constructed a wireless site. It could be Comcast wanting to upgrade a line, could be the city coming in wanting to add fiber network to serve other agencies, could be streetlights. So we'd like to see a little more flexibility in the way that that's written, or maybe a little bit different interpretation on that one. And I think that's pretty much all that we had, with the exception of it talked about utility structures outside the right-of-way, and we'd like a little more clarification on that, whether or not this would apply to power poles that are on private property, and if so, would these be subject to the accelerated permitting standards currently used in the right-of-way, or would this be subject to the full land use process? And that pretty much covers everything we had.
Any questions for Mr. Carver? Don't see any. Thank you very much. Next is Stephen Top. And just so you can get ready, next will be Ed Fournier. Good evening.
Good evening. My name is Stephen Top. I'm a land use and development consultant. My primary clients are in the telecommunications industry, but I do other planning as well. Basically, I have submitted some comments throughout the ordinance that are in the record, but there's a fundamental concept that I wanted to have you at least consider or think about, and that is why it is that you are including the power pole and the right-of-way into the land use ordinance. The City of Portland kind of excluded theirs, but they did try to incorporate it by saying that you have to, you can't have a new tower if you can go on a power pole. But then people were coming up and saying, but we don't want it on the power pole because it's on the corner here and it's very visible. We'd rather have it in the park here, which is on private land. But we couldn't do that. So since the city owns the right-of-way, or at least has the license on it to allow for the poles to be done in the first place, I'm not sure what you're really trying to accomplish by having it in the land use ordinance. Any reviews can be done by the city, and they could simply say that if we haven't provided them the information they need, perhaps we wouldn't allow them on that particular pole. Now, I understand the need to have a public comment period or a notification to the residents that, hey, we're looking at a power pole here near your house, and we do that for Portland as well, where we have neighborhood meetings. But that's just a general concept I wanted to throw into there. At the same time, I've heard a couple times tonight about and this is just a thought that came to me as I was sitting there, is the property values. That's a common thing that comes up in the hearing for when you go to a public hearing situation, much as the same as the health effects do. And the response that we always have to give is that if you don't allow it here, you're just simply transferring it from in front of your property to in front of somebody else's property. So I would really like to see the concept of property values effect be taken out of the equation when you're reviewing these applications, because it's going to affect one person no matter what. Throughout the rest of the things there was just a couple of items that I wanted to focus on. On page 5, item B, co-location required, the wording tends to indicate that the carrier has to consider all existing structures within a search ring regardless of height. And a search ring can be a quarter mile. So I might have to go out there and identify all 60 single-family residences and identify why I couldn't go on top of their roof before I could go on to the next alternative. So I think there needs to be some leeway with that requirement. We've got so many comments that I have to focus on the primary ones. Page 8, item D, I'm not sure, it says an alternative analysis for new support towers demonstrating compliance with the support tower siting requirements have to be done within 250 feet of the proposed location. So I have to identify within 250 feet other properties I could go on with that tower. So then does that mean that in terms of my client, I have to go out and secure lease options with the 3 or 4 other properties that I could conceptually put a tower on that are equally as viable as the site that I'm on? It makes it very cumbersome. Still no orange. Page 12, flush mounted. Flush mounted is not defined, but antennas may need to, and typically do, extend out from the structure at least a bit, at least a 1-foot davit arm, if not a 3-foot davit arm. This is also very important in terms of the power poles, where PGE, and Jim didn't get a chance to mention this, they require for their own safety people to be on 3-foot davit arms so that they can climb up between them to get to the power lines above. And yet the way your code is written, if it's below the power lines, they have to be on 1 foot or flush mounted. And that does not coincide with what PGE's safety requirements are. I do have concerns about table 715.1, which is the heights, especially in terms of the FU, which is eventually intended to come into city standards and more likely a subdivision standard, but residential standard. But 35 feet is very difficult to be effective for any type of facility. 50 feet is also very difficult, but at least it's more doable. Along those same lines is the concept, and I did a lot of the Clearwire sites that we did, maybe 10% of the sites we did were on power poles, and we tried to put them in 32-inch canisters on top of the power poles, which allowed for 3 antennas. In terms of the other carriers, like AT&T and T-Mobile, they're putting up 6, 9, 12 antennas to cover all their various bases. You're not going to be able to get those in canisters, and power poles are not going to be a real option. But the way the code is written right now, it doesn't allow you to consider that aspect when you're ruling out building a new tower, or ruling out a power pole before you go to build a new tower. And yet, you need to have that room to have the additional antennas. So then, other than that, questions?
Any questions for Mr. Top? All right, thank you. Next is Ed Fournier.
Good evening. My name is Ed Fournier. I'm with Land Services Northwest, and I'm a consultant for Verizon Wireless. First of all, certainly wish to thank city staff and especially Pamela Cole for the opportunity to be involved, well, let's just say for quite some time with this draft of the ordinance that's before you. And certainly also appreciate staff's incorporation of a number of the items that were listed in Verizon Wireless's outside legal counsel from McKinsey and Albatron as well. I will not reread that document, and I've also crossed off a number of items on my list as well because they've been addressed by previous industry representatives. Part which has not been touched on and was touched on in the letter from Verizon Wireless outside legal counsel is the concern with the nature of Section 715-100 sub B as it's currently written. It's a very short paragraph, but it requires that a applicant cover all of the costs the city may incur in review of an application that has been submitted. There's not a reasonableness clause, and that is certainly something Verizon Wireless would be interested in seeing. This could be potentially construed or maybe abused so that additional staff hours could be added for, say, the cost of determining what consultant to use and perhaps what part of the application would require a review. Could a engineered analysis done by a state of licensed Oregon licensed electrical engineer that's been stamped subsequently require yet another electrical engineer to be outsourced by the city to review the calculations of that engineer, and then so on and so forth beyond that point. In theory, the city could also outsource the vast majority of the actual review of the application from stem to stern. I certainly don't think that is the intent. But certainly we ask again for a reasonableness standard to be inserted, and also that there be some requirement that those reviews are ones that are done that are reasonably beyond the city's level of expertise they would have on hand. Can they read maps? Can they look at basic criterion? Can they review photo simulations? Certainly. Maybe some of the engineering documentation does require a third-party outsourced consultant for review, but again, we ask for some reasonableness and some limitation to be added to that. Beyond that, again, I will not reiterate the points that are raised in the letter by Verizon's outside legal counsel, and certainly can address any questions that you have at this time.
Any questions for Mr. Fournier? I have one because you may be the last of the wireless representative folks. My sense in this ordinance is that there's nothing that prohibits you from accomplishing your goal of serving customers, but that the level of frustration and process and expense is seemingly overwhelming. Is that a fair statement?
In part, again, prohibition of service is a rather hot button issue, and I wouldn't think this would be the forum for it. I think one of the biggest concerns, again, was expressed initially by the T-Mobile when you talk about, say, the residential areas or levels of reviews to be done, is the difficulty in what probably is 80% of my work right now, which is capacity. It's not adding new cell sites because we don't have coverage in location A or B, and I think this is a trend for the industry, but again, on capacity issues. Again, was mentioned out, I didn't see that it was only written twice in the code, but that's one of the items that was mentioned earlier today in the documentation. Again, that is a big concern, and certainly one that was raised in the letter by Verizon Wireless's outside legal counsel as well. Again, prohibition of service is a real key phrase, and I certainly don't feel that it's my part to comment on that at this time. Very difficult, cumbersome, certainly. Beyond that point, again, I don't feel comfortable making that. Each location is very unique. The service requirements, coverage, capacity, topography, a myriad of other issues, also all the way down to the frequencies that each carrier has to work with. Verizon Wireless actually has 4 frequency bands that they're mandated to utilize. Other carriers have maybe only 2, some up to 4, maybe even more as we move ahead in the future. So again, it's not only that, but needing to deploy each one of those in a location. Perhaps doing so on a phone pole in a residential area might work for a Cricket or a Clearwire that has a single or maybe 2 frequency bands, 4 frequency bands, and the number of antennas and equipment that are required to do it. It can't reasonably be done at this time. I apologize, that's not a yes or no answer, but it's not one that I can easily answer that way in black and white.
All right, any other questions? All right, thank you very much.
Thank you.
Next on the list is Sally White.
Good evening, and thank you for listening to me. I am not an industry person, but I would advise the Planning Commission to listen to all of their concerns. I think the concerns that they brought up were legitimate. On the other hand, I also would like to see someplace along the line where the city is going to monitor their emissions at one point or another, only because, you know, it's like if you have somebody monitoring themselves, sometimes it doesn't work out so well. One of the things I would like to bring up is possibly just to put in one little mention where along places like Wallace Road, I live on Wallace Road, that was heavily impacted when 221 was put in. So maybe when cell towers or just antennas, everything is put in, let's look at what's going on with the property owners there and how it may adversely affect them, instead of putting it in one more thing that's on Wallace Road. Other than that, I was really impressed with what the industry people said, and I would hope that the planners would look over what they're suggested very carefully. Thank you.
Any questions for Ms. White? All right, thank you. Next is L.R. is it Schillen?
Good evening, Commissioners. My name is Laurelyn Schellen. I reside at 606 14th Street, which is in Ward 1, and have been an active in Nen Neighborhood Association for over 33 years. Unlike most of the other speakers, I have no connection to the wireless industry. But like you, I have been a City of Salem volunteer serving on the Neighbor to Neighbor Board of Directors for 6 years and a former Land Use Commission member. I also helped the City Environmental Commission research electromagnetic field issues in 2002. That information is relevant to this hearing relating to siting, setbacks, and tower heights. We found that wireless carrier EMFs are linked to such diseases as childhood leukemia, breast cancer, and brain cancer. The National Council on Radiation Protection called for government action to curtail the exposure of the public to EMFs. This affects siting, height, and setback decisions you will be recommending to the City Council. We learned that the World Health Organization advised that government decisions on siting EMFs should consider ways to reduce the public's exposure. We also learned that in January 2002, 18 months after an electromagnetic field was sited near an elementary school, there was an outbreak of child cancer at the school. The court ruled that EMF was responsible and ordered it removed before the school could reopen. The new cell code does not address these concerns of protecting our schools. And then we're especially concerned we have elementary, middle, and high school students. So you see, the city has an important responsibility to its residents to carefully site EMF structures. As a city, we should not expose our citizens to higher risks. The city of Corvallis has taken the responsible position of burying all power lines to reduce EMF exposure. Setbacks are also an easy way of dealing with the public health, safety, liability, and property values. I understand the intent to consolidate related ordinances into one code chapter and submitted written testimony which I request be entered into the official public hearing record. Have you received a copy of my written testimony? Have you had a chance to look at it? It's divided into two sections. One is neighborhood concerns and remedies. We can put underground equipment in residential areas to address the neighborhood noise, aesthetic, and health concerns. We can retain the current code 300-foot residential setbacks to help minimize neighborhood health concerns for emissions. This is the minimum residential setback recommended by the World Health Organization that has linked 4 times as many cancer patients and a high rate of childhood leukemia to living near cell towers. Maintaining the existing 300-foot setbacks reduces EMF exposure. And as Ms. White testified, revenue fees paid to the city can monitor EMF levels. Monitoring is needed because, and I quote Ms. White, when someone monitors themselves, it doesn't always work out too well. Well, court cases have shown that the Federal Communication Commission's allowable levels for emissions have been exceeded when not independently monitored, to the detriment of the public's welfare, particularly the most vulnerable. The city sets EMF, the FCC sets EMF limits which the city can and should monitor for compliance. This is in the city's best interest. I see my time is nearing its end. I urge you to take a look at the other written comments, particularly the appraisal journals, sales loss of over 20% for residential homes near wireless facilities, the sending notice to property owners. Many property owners have requested they be notified. There is no reason to limit it to 250 feet. Especially the elderly, disabled, and other homebound residents that don't see a notice published on a property need to be noticed. And the city can easily maintain a list of interested property owners and send a list out, notification list. Also, the public notice and comment period is outdated. The proposed 14 days from the date notice is mailed is insufficient, given that the U.S. Postal Service is discontinuing weekend mail service. Property owners may be out of town for business or pleasure, and 14 days is not adequate time to research or prepare comments. A 30-day comment period is more consistent with the notification policy of other county, state, and federal government entities. And this is keeping with the city's policy of encouraging residents to become involved in city planning and governance, as you all have. Thank you.
Are there any questions? Don't see anything. Thank you for coming
Thank
down. Next is Pete Dane.
Oh, good evening. My name is Peter Dane. I live at 720 Capitol Street Northeast in Salem. And I submitted some comments to Mrs. Cole's office, and I brought along some documentation. And I'd like to say that an increase in cell towers may be a mixed blessing. It will promote electronic related commerce. As part of the First Responders National Network, it will improve better access for personal, emergency, and medical needs. On the downside, more cell towers will increase EMFs. Anyway, those are my comments. I'm going to leave some documentation with Ms. Cole. Are there any questions?
Any questions for Mr. Dane?
Thank you.
All right, thank you. I don't see anybody else signed up on the list. Is there anyone else in attendance that would like to speak to the Planning Commission on this public hearing issue? If you would like, if you'd come forward. All right, I don't see any. We'll move now to questions of staff. Are there any questions from the commissioners? Commissioner Fry.
In the testimony that we've heard tonight, there was some comment about replacing a tower with like for like would require a public hearing.
Under the current proposal, we do have it as the level 5, which would require a type 3 process, including a public hearing. I do understand the comments that the providers have raised. We recently received that document from the FCC, came out in January after we prepared this draft. And I've also attended a seminar to try to learn more about the implications of the federal law and how we might need to address that in the code. So we were aware that there may be some issues related to that.
So that is something that staff is looking into?
Yes, I agree.
Okay.
We should look into
Also,
that.
there was some comment about a difference between rooftop being different from tower-mounted antennas.
Right, I believe we used an earlier definition than has been provided by the FCC in their guidance memo. So we'll take a look at that as well.
Okay, and then the only other question that I have is, if we're requiring a 1-foot arm on the antennas and they're mounted on a PGE pole and PGE requires a 3-foot arm, that seems like that would be of some concern to the city.
The intent of not putting in a provision for a 3-foot arm was that we wanted the properties of the facilities in right-of-way to look more like a utility pole and less like a cell tower. And I believe you could, in some circumstances, put shorter arms. It's just going to be where it is in relation to the transmission lines. And if you have a pole and you're only putting one set of antenna, then I don't understand why they would need the 3-foot set unless they need to place those below the transmission lines. I believe that was the issue.
Right.
But if you'd like to address that, Mr. Carver?
The National Electrical Safety Code has clear guidelines for what needs to be allowed as a climbing space for a utility worker to ascend a pole up to where he needs to work. That code is also adopted each revision by the state of Oregon as state law. The PUC here in Oregon has mandated that every utility pole be a climbable structure. That is, a worker has to be able to start at the ground and climb to the top of the pole. Some of our line guys are pretty good size. Know several of them that probably go way past 250. By the time they get their belts and all their equipment on, if you're dealing, by the time you get over to the top of the pole, you're dealing with a structure that's basically 12 to maybe 15 inches in diameter. So if you get the antennas in pretty tight, it's pretty hard for him, particularly in a situation where the antennas aren't mounted at the very top of the pole. Now, if they're mounted at the very top, if they're on extensions above the pole, it's not so much an issue. But we do have sites where it made sense at the time to mount the antennas between what we call distribution, the voltage that would serve your house, and what we call transmission, the voltage that goes from substation to substation. And it's in those situations particularly that we have the issue of trying to get past the antennas to do maintenance on the line. PG's policy is not so much that we're worried about the RF. We require that the sites be shut down if our workers are up there. We don't have a training program where every lineman knows what the RF standards are, has the equipment to monitor it. So it's more, like I said, an issue in very few cases, but to prohibit it, it certainly limits our options.
So if I could just ask a follow-up question. On a tower that there's only 1 or 2 antennas, it probably wouldn't be as big an issue as if you had 5 or 6 antennas.
That's correct.
And it sounds to me like we're going to have 5 or 6 antennas on most of the towers that we have out there in the future. Is that correct?
That's correct. Right now, I'm involved in upgrading here in the Willamette Valley, I think approximately 80 wireless sites from different carriers. In every case that I'm dealing with, they're adding at least one more set of antennas. Some of them are adding two. To my mind, it's like, maybe it's just cheaper to give everybody a new 4G phone, but evidently they have people with 3G phones and 2G phones, and, you know, they have to serve all of them, so.
All right, thank you very much.
Any other questions of staff? Commissioner Below.
Thank you. I just have a couple of quick follow-up questions, and I apologize, fairly new to some of this. Could you please clarify the requirements for the proposal of the 75-foot tower and the requirement for the camouflage for that? Could you just clarify that? So going from 35 feet to the proposed increase, could you clarify what the requirement would be, when the requirement would come into play as far as the camouflage or any other requirement for the increased height of the towers?
If I could answer that, is the height a separate question, the camouflage? And are you concerned that we're proposing to increase heights in some zones?
Not so much a concern, but just what the, if that were to go through, what the associated requirement for that would be for the camouflage requirement for that.
Oh, I see. For an existing tower that's increasing in size?
Correct. Thank you.
In the proposed design standards on page 17 of 21 in Chapter 715, under design standards, it does say it shall apply to support towers in all residential zones, mixed-use zones, commercial office zones, or public and private cemetery zones, and support towers located within 300 feet of those zones. And that specific clause in letter E doesn't say that it would only apply to new support towers. And when we look back at the beginning of section 715.070, support tower development standards, it indicates that those standards apply to construction of a new support tower or replacement or substantial increase in size of an existing support tower. The way it's written, I believe it would apply to those substantial increases in size. And if we leave those as a type 3 process where that's appropriate, I think that that was the intent. I understand their concerns about replacing an existing tower like for like, and I would like some guidance on whether the Planning Commission believes that that's an area where we would want to go back and apply those design standards.
Thank you. Thank you.
Any other questions?
I'm sorry. I have one
Yes.
last one. I promise it'll be the last question. Going back to the question I had originally relating to, sorry, I need to look here real quick, the 3 priorities versus the 6 priorities. So some of the industry folks are proposing reducing the number of priority levels to 3. Could you please clarify why we're staying consistent with the 6 priority levels versus the 3, and speak specifically to the wording relating to right-of-way and within the right-of-way and out of right-of-way?
When we initially decided on the siting priority, we did prefer that co-locations or antennas would be attached to structures outside of right-of-way. That was the policy choice. And then allow, if those options didn't work, to allow co-location inside of the right-of-way. The priority was strictly a policy choice by the staff that has been working on this for quite some time. And I can understand there may be different perspectives where we might want to prefer facilities in right-of-way over facilities on private property. We drafted it in this fashion and tried to make sure that all of the development standards followed along with that priority.
Thank you.
Okay, I have a couple questions. One, we're not inventing the wheel here. How does the proposed Salem city ordinance compare to other cities that you have looked into as far as the provisions of the ordinance? Are we copying what you've seen in other places? Are we demanding more, demanding less? Have you looked at other places?
We have, and our consultant that's been working with us since 2009 has also looked at other ordinances. She prepared some initial drafts for us. And at that time, we were thinking we would have a separate chapter for the facilities in right-of-way, another chapter for facilities on private property. As we went through the process and wanted to make sure that we followed the construction of the Unified Development Code and the format, we decided to place everything in one chapter. So we combined provisions outside right-of-way and inside right-of-way.
Jim? And if I could just add, and I think our consultant would confirm this, if we came to a policy choice and we were weighing in favor of expanded coverage, expanded capacity, expanded deployment versus compatibility and protection with the neighborhood, we probably, in all honesty, erred on the side of protection of the neighborhood. That's just how we looked at it. Planning Commission, City Council certainly could do something else, but we did err on the side of caution, if you will.
And Ms. Beery, at one of the previous work sessions, did state that she felt that this strategy was fairly aggressive in regards to the right-of-way facilities in particular. It was something that was new and different, and not a lot of jurisdictions have attempted that. Portland's code regulations are different because they do not apply zoning in right-of-way. So they have an entirely separate section that deals only with facilities in right-of-way outside of zoning.
Our consultant is an attorney, has a vast amount of experience in this area. She did, of course, say that she thought the ordinance would stand. It was defensible on its face.
Second question, and that is regarding, I think it's the FCC rule that we heard about, 6409. Do you feel you have enough understanding of where that's at right now to continue, or do you think you could use more time to review that and possibly change anything in the ordinance?
I do believe I would need a little more time to look at that. The FCC's guidance memo came out at the end of January, and I attended a training session recently and have a lot of materials that I need to go through, because we just had an hour or two to go through that as an audio seminar, and I have a lot more information that I need to review. And you do have a different perspective from a municipal lawyer, perhaps, who was conducting the training than we have from the wireless industry. So we do need to review that and reconcile differences and decide on the best course of action.
Well, if I might ask a procedural question, because my sense is that I would agree that we could possibly use some more time to look at it, possibly refining the proposed ordinance, possibly not. As a practical matter, can we close this public hearing and have staff do that, or do we need to leave the public hearing open? How would we go about doing that?
You have the option of closing the public hearing portion and leaving the record open, so if we wanted to make changes to the staff report or to the proposed ordinance, we could do that.
Okay, let me ask my fellow commissioners, any thoughts? Well, first, let me ask if there's any more questions of staff before we get into deliberations. Commissioner Fry.
If the Planning Commission decided to give you more time to look into these issues, how much time do you think you would need?
We could set a date certain that's appropriate. I would imagine 3 or 4 weeks would be appropriate. Do we have any dates in mind?
We do.
March 19th or March 26th? Are those, either one of those meeting dates?
And there were additional issues raised this evening that I hadn't had a chance to review before, so perhaps the second date would be more appropriate.
Okay, well, that's fine, because March 19th is a regular planning commission meeting, and it is full. I don't know if pushing this out to April 16th causes the city any discomfort. I know you've been working on this for quite a while, but my thought is rather spend a little more time and get it right than take a chance that we don't. And so pushing it out to April 16th could be an option.
If I could, President Lewis, we've been working on this for 3 years now, and if the commission thinks you need that much time, certainly then that's fine. If you think you could possibly make a decision on the earlier date of the 26th of March, it would be my preference that you do that. As I understand it, it's likely that the testimony portion of this hearing is closed, and you're keeping the record open. We could keep the record open. We could produce a staff report and come back and let you deliberate on the 26th if that works for you.
Just for clarification, I'm looking at the Salem Planning Commission tentative agenda. It talks about the March 5th and 19th, and then again April 2nd. So I'm missing
This would be a
April
special
26th.
meeting.
This would be a special meeting on the 26th?
Yes.
Okay.
Commissioner Blasey.
Thank you. So I would like to clarify, there are a couple other questions I think that we probably want to have staff address as well, as Ms. Cole mentioned. One, with regards to the difference between a 1 foot and a 3 foot safety area between that, so that we ensure that we're in compliance, or not necessarily compliance, but we're meeting the needs of the safety needs as proposed by PGE. And then there were a couple of others as well. So will that give sufficient time to address all of those questions that have come up?
Pamela, what do you think?
I believe so.
Commissioner Williams?
Would staff have any heartache about leaving the hearing open to that first date, March 26th, simply because you may have additional testimony from the carriers, depending on the extent to which staff will be looking at and correcting.
Yeah. Well, that's certainly your option. That'd be fine. Yeah.
Although if I understand correctly, if we close the public hearing and leave the comment period open, then that leaves the opportunity for anybody to file written comments up to a particular date?
Right. Was your concern, Commissioner Williams, that folks might want to comment on the staff report that would be prepared for the next hearing?
Yes.
Yeah.
To the extent that, we have significant changes, and there could well be quite a few changes in that. So I'd just like the opportunity for other people to maybe, if they haven't had a chance to comment at all, or you have additional comments to be received.
Yeah, that would be fine with staff. It's the Planning Commission's option, of course.
Right.
Okay, so from a procedural standpoint, if we hold a special planning commission meeting on Tuesday, March 26th, when would we be able to, and when would the public be able to expect the staff report so they could prepare any comments to bring forward on the 26th?
We typically try to get the report out a week beforehand. Should be available a week before that, so the 19th.
Okay, so if I can ask Ms. Cole, if you think you'd have enough time to do what you need to do and have it all written up by March 19th?
Yes.
Okay. Okay. My sense is that we are, I don't want to speak for anybody else, so I'll speak for myself. I like the idea of keeping the public hearing open and continuing it on Tuesday, March 26th. And so I'll make that motion.
I'll second that motion.
Any other comments? All right, all those in favor of the motion, say aye.
Aye.
Aye. Any opposed? All right, thank you. That brings us to the second opportunity for appearance of interested citizens. If there was anyone here who wishes to speak to the Planning Commission, if they would come forward. All right, Urban Planning Administrator's report.
Real brief for the information of the commissioners. We did conduct a couple briefing sessions with our new planning commissioners, and we had a nice time and a chance to, orientate them to the various projects that we're working on, and look forward to working with our new planning commissioners.
Commissioner, comments for the good of the order? I have one, if I could. I believe that we have now some vacancies on some of the city's advisory boards and commissions, and I would request that the staff bring back those vacancies at our next Planning Commission meeting so we can ask for volunteers from the Planning Commission to sit on those advisory boards and commissions.
We can check on that. We're not aware of any vacancies, perhaps.
One is the Downtown Advisory Board. Dargos was although he was not a member from the Planning Commission. The other is the Capital Planning Commission. And I believe Dargos served on that commission as a representative of the Planning Commission.
All right, we'll check into that.
So we'll bring back forward more opportunities for volunteerism. That's great. Okay, any other comments? All right, thank you, and I appreciate the work that the commission has put in, and I want to thank the folks that appeared tonight. With that, we are adjourned.